Ladies and gentlemen, thank you so very much for tuning in. We have a lot to talk about, and what we're going to talk about today, and there's a lot of discussion, of course, regarding impeachment. And, well, first and foremost, oh my lord, are you kidding me? There's a lot of talk regarding impeachment, and the impeachment inquiry, or the impeachment hearings regarding President Trump. Now, that is tied directly, absolutely directly, to the Supreme Court. And it's tied to the Supreme Court because President Trump, under Article 2 of the Constitution, has the right to nominate Supreme Court justices. Now, Democrats did this to themselves the way they usually do things to themselves all the time. They cheated Bernie Sanders. They lost. They now want to redo the election. And they cheated Bernie Sanders. You can read the DNC emails. It's not a very difficult thing to understand. They cheated Bernie. They went with Madam Secretary. They're going to go with Madam Secretary again. And Clinton's going to run again. This is a grandiose arm wrestling match between two factions of political influence within the United States government. And they ain't going with Biden. They ain't going with Bernie or Warren. The issue at hand is what happens if, because one Supreme Court justice did not was not present the other day because of some issues. What happens if the Supreme Court goes 6-3? Right now it's 5-4 conservative. President Trump has 2 Supreme Court nominees that he's already nominated. The question is, what happens if it goes 6-3? With the way the Democratic Party is, it's probably better for the country. Now, major decisions, whether it's Roe or any other decision that's grandiose, I don't think will be overturned at all with a 6-3 or even a 8-1 Supreme Court. But you have to understand also that President Trump is president. He's going to win re-election. They know this. They can't defeat him at the ballot box. So they're going to try to remove him with the special counsel. That didn't work. He never colluded with Russia. That's a bunch of nonsense. And also, they're going to try to impeach him because of a phone conversation that diplomats didn't agree with. Now, all of this is just theater. The Democratic primary is even... It was actually more fair and neutral in 2016. Because at least there was a chance that somebody other than Madam Secretary could win. If it was fair, Bernie Sanders would have won the Democratic primary. They cheated. Then they then, prior to cheating, they said, well, Clinton's going to win the election. Let's make Supreme Court nominees. Let's have just a simple majority. Mitch McConnell said, you are going to regret this decision. Harry Reid at the time said, no, we're not going to regret anything. They did this to themselves, just like cheating Bernie Sanders. So this is interesting. Let's listen to this. This is Chuck Grassley. So you know what Dianne Feinstein said. Well, your religious beliefs might get in the way of your decision making, and of course, Amy Coney Barrett, I guess her background was not considered, I'm not going to get into it on live stream, but her background is not considered a background where they have to walk on eggshells. So Dianne Feinstein makes this outlandish statement, well, maybe your value system or your beliefs in a higher power or whatever, your theological viewpoint might make it difficult for you to to look at decisions in the court. Now, this is actually worse, or just as bad, I should say, as what President Trump did during the election when he said, well, this judge is voting against me. I didn't agree with what President Trump did. That was wrong. But this is equally as wrong, if not more egregious. You can't go. So Amy Coney Barrett's going to be next. If there's a vacancy, she's going to be next. She's a woman. Democrats cannot pull the same type of nonsense they did regarding the last nominee. And here's Chuck Grassley. So we know what Feinstein did. But here's Chuck Grassley, and here's Amy Coney Barrett explaining that her viewpoint is going to be just interpreting the Constitution without any hindrance. Here she is. Here's Grassley, and here she is.
I'm going to start with you. You've been outspoken about your role and your Catholic faith and what that plays in your life. And you've thought and written about the role your faith should play in your profession. So I'd like to specifically discuss a law review article you wrote during law school entitled, quote, Catholic Judges in Capital Cases, end of quote. In this article, you seem to suggest that Catholic judges are, quote, morally precluded from enforcing the death penalty, end of quote. However, you also wrote that, quote, judges cannot and should not try to align our legal system with the church's moral teachings whenever the two diverge. First question, you've had a couple decades of experience since you wrote this to consider this issue further. Will you elaborate on these statements and discuss how you view the issue of faith versus fulfilling the responsibilities as a judge today? When is it proper for a judge to put their religious views above applying the law?
Thank you, Chairman Grassley. Let me start with your very last question and say never. It's never appropriate for a judge to impose that judge's personal convictions, whether they derive from faith or anywhere else, on the law.
So she's pretty clear. She's pretty clear. So Grassley and then Democrats, well, Grassley's probably giving her an opportunity to explain her true viewpoint, but she said never. It's never appropriate for any judge to utilize whatever theological belief they have, any vantage point they have that is not strictly rooted within the Constitution. The Supreme Court, the Democrats love to talk about separation of powers, and they love to talk about how you can't be prejudicial, and they love to judge bias. You can't be biased against a person because of the person's background or their beliefs in a higher authority. You cannot judge somebody based on who they are. But with Amy Coney Barrett, they certainly did that, and she states categorically, she's not going to put any theological viewpoint that she has above what the Constitution states. So this is her. So she states it categorically. Carl's opinion. By the way, Carl's opinion. Thank you very much. Yesterday, I didn't get a chance to thank you. Thank you very much. Just thank you very much for yesterday. It was after the segment, and thank you also, Carl's opinion. Thank you. Good evening, Mr. Goodman, mods in chat. Hello, Carl. Thank you. Everyone subscribe to Carl's opinion. Everyone subscribe to Carl's opinion. Everyone. He's awesome. All right, let's continue. You know what? Let's continue.
This article that I wrote as a law student has gotten a lot of attention since my nomination.
Yes, the Catholic judges are, quote,
relative statures.
To
work on it with him, and I was complimented that as a student he thought I was up to the task. Viviano family
to consider this issue further. Will you elaborate on these statements and discuss how you're...
So I'm not going to interrupt Amy Coney Barrett, but listen to, this is a C-SPAN Judicial and Justice Department pending nominations, September 6, 2017. This is really important. So she puts to rest any concerns that her theological background would hinder her decisions as a Supreme Court justice, because this is what's going to take place. And Trump knows this. Trump is going to play this masterfully. I think he's going to pick Amy Coney Barrett. He must, actually, because not only is a woman, not only is a person of faith, but as a human being who she is able to kind of serve as a mirror to the Democratic Party's duplicity and disingenuous nature regarding their alleged value system on how you can't be biased against people. But this is, when she was a law student, she wrote something that they don't like, and she's clarifying it. She stated categorically she will not let any, viewpoints regarding faith prevent her decision-making or influence her decision-making. But here's Amy Coney Barrett.
You view the issue of faith versus fulfilling the responsibilities as a judge today. When is it proper for a judge to put their religious views above applying the law?
Thank you, Chairman Grassley. Let me start with your very last question and say never. It's never appropriate for a judge to impose that judge's personal convictions, whether they derive from faith or anywhere else, on the law. This article that I wrote as a law student has gotten a lot of attention since my nomination, so I'd like the opportunity to put it in context. I wrote that law review article when I was a third-year law student with one of my professors 20 years ago. It was a project that he had underway, and he invited me to work on it with him. And I was complimented that as a student, he thought I was up to the task of being more than a research assistant. But I was very much the junior partner in our collaboration, and that was appropriate given our relative statures. Would I or could I say that sitting here today, that article in its every particular reflects how I think about these questions today, with, as you say, the benefit of 20 years of experience and also the ability to speak solely in my own voice? No, it would not. But I continue to stand and vehemently believe the core proposition of that article, which is that if there is ever a conflict between a judge's personal conviction and that judge's duty under the rule of law, that it is never, ever permissible for that judge to follow their personal convictions in the decision of a case rather than what the law requires.
So she's being honest. She's saying, look, if any judge had a personal conviction that prevented them from looking at a case objectively, well, then that person should recuse, or, And so that, it's interesting, that is apparently not enough for Senator Feinstein. So, and she had already answered that question prior to when Feinstein says, well, there's this ideology that lives within you. It's like, oh my God. Hidden for time! Feinstein's social beliefs prevent her from stepping down from a queenly throne. Hidden for time. Thank you. Cosmic Shy. Thank you, Cosmic Shy. I appreciate that. I have my viewpoint regarding that whole thing, but I do appreciate your support of my work. Thank you, Cosmic Shy. Thank you. Hidden for Time. Thank you. Thank you, Cosmic Shy, and thank you, Hidden for Time. Let's continue.
That article emphasized that point repeatedly, and I adhere to that today.
See, started the clock.
I have my...
mean this on purpose, but somebody needs to start the clock, so, there it goes. Follow up. If you're confirmed, how will you decide when you need to recuse yourself? Then I have two more questions for you.
Yes. Senator, I would fully and faithfully apply the law of recusal, including the federal recusal statute, 28 U.S.C. 455, the canons of judicial conduct. What I can tell you is that sitting here today, I can't think of any cases or category of cases in which I would feel obliged to recuse on grounds of conscience.
Okay.
So what they do is, you see how deferential Chuck Grassley is. You see that Chuck Grassley, he doesn't say, oh, I'm Spartacus and all this stuff, and he's so deferential. The Republicans are just so deferential. Oh my God, are they so deferential? Oh my God, are they they're so worried what the Democrats think. They want to, because they just want to appease the Democratic Party. Oh, please trust us. It's okay. You have nothing to worry about. They don't even need a Democratic vote. What are they doing? They don't need a vote from them. They own the Senate. They run the Senate. You see what's going on with impeachment now. You see how they treated President Trump's prior nominee. You see that they're not genuine. They're disingenuous. They're duplicitous. They crave unmitigated political influence. And then you have Chuck Grassley, and I don't blame him. I don't blame Chuck Grassley. You understand? I do not blame Chuck Grassley. He's actually doing a great thing in terms of trying to be deferential. But he's acting in a manner that they don't act in the same manner. That's my point. That's my point. And you'll never appease the Democrats on the Senate. There's no appeasing them. So let's continue.
You've written and spoken much about the legal doctrines related to precedent and stare decisis. Please describe how you understand circuit court judges to be bound by precedent of the Supreme Court and your understanding of stare decisis.
I understand circuit judges to be absolutely bound by the precedent of the Supreme Court, and the Supreme Court has held in a case called Rodriguez de Quias that obligation is absolute. That circuit court judges are not permitted, for example, to anticipate overrulings of the court and jump the gun. Circuit courts are absolutely obligated to follow Supreme Court precedent. And as well, circuit courts are bound to follow the precedent of their own circuit according to the circuit's doctrine of stare decisis. And for example, in the Seventh Circuit, that means that judges follow precedent unless there are extraordinary circumstances that justify its overruling.
Okay. And lastly, as we just discussed, circuit court judges are required to follow all Supreme Court precedent. If confirmed, would you follow Supreme Court precedent involving abortion?
Absolutely, I would.
Okay, now, Justice Larson, during the Supreme Court hearing earlier this year.
So, here you have the issue of, here you have the Senate. And the Senate doesn't even need to act in this manner. That's my point. You have Republicans on the Senate who are trying to play fair.
Article stands for itself.
Here's a Democratic senator who is not playing fair. Listen to this Democratic senator.
Your earlier writings.
Well, Senator, what I said to Chairman Grassley in the beginning is that I did write that article as a student 20 years ago, and that I would not say that the article in all of its particulars represents my view today, that with 20 years of life experience, I would, and speaking in my own voice, would describe things a little bit differently now. But what I said to the chairman and what I'm saying to you now is that I continue to subscribe to the core argument of that article, which is that a judge may never subvert the law or twist it in any way to match the judge's convictions from whatever source they derive.
So that's not good enough. She already stated, you understand? She already stated, look, this was an article that I wrote as a law student 20 years ago. I'm not going to overturn anything. I'm not going to base any of my decisions on... I'm not going to base any of my decisions based on any, religious or, faith-based viewpoint. But it's not enough. That's the issue here. The issue here is that the Democratic Party, they don't play fair. They don't play fair, and they certainly don't. Because if you alternated Amy Coney Barrett with somebody of a different background, well, my God Almighty, they would never allow the type of questioning. They would never allow the type of questioning. But let's continue.
And that was what that article repeatedly said, and it's a position to which I adhere before you now, under oath.
Well, it was a 50-page article, as you say, and other people can draw other...
So she goes, okay, the senator from Hawaii goes back to the article, regardless of the explanation, and just harps on it continuously. Let's continue.
Conclusions. So it was enough of a statement of what you believe the role of religion was that it certainly caught my attention, because I thought that justice was supposed to be blind. So let's say that you did, as you say, you acknowledge that in all of its particulars that you have changed your views about some of the things that you wrote in the article. And I hope that you can maybe very briefly, because I'm running out of time and I do have other questions for you. Maybe you can just submit for the record then what other parts of the article that you no longer subscribe to. That would help me. Let me go on to my next question.
What? She didn't even allow Barrett to answer the question. It's hilarious. She wrote a law school article, an article as a law student with a professor, where the professor had the senior role, where the professor was actually talking about the professor's voice, let's say, or viewpoint was actually more prominent. It was 20 years ago. Barrett states categorically that she would not let any religious viewpoint, any faith-based viewpoint, get in the way of her interpretation of the Constitution. States that categorically. Still not good enough. Still not good enough. It's pretty unbelievable. It really is pretty unbelievable. But let's continue.
I want to ask some questions about the article that you wrote relating to super precedents, and you made it very plain that was not your list. But did you agree with that list of super precedent decisions?
Well, Senator, let me first say, as I said earlier in response, that from the perspective of a Court of Appeals judge, all precedent is super precedent. On that list of super precedents, again, I was using a list by other very well-respected
scholars. Well, my question
scholars.
is, I realize that. I'm sorry, I'm running out of time. So did you agree with that list, even if it was not a list that you had compiled?
According to the definition of super precedent employed by those scholars, yes. If you use a different definition of super precedent, for example, a precedent that's more than 40 years old and that has survived multiple challenges, then I would include Roe on that list. It wasn't the definition.
You would include, did you say you would include Roe on that list of super
If
precedents?
super precedent were defined differently, super precedent is used differently in different contexts. And in the particular context in which I was writing, the particular definition that was used, it did not satisfy that definition. What I'm saying is that if you use a different definition of super precedent, which some people do, I think Roe could satisfy a different definition. I would also point out in language that I quoted from these other scholars that Professor Fallon at Harvard specifically said that the exclusion of Roe or any other case from the list does not mean that it should be overruled. But again, for a Court of Appeals judge, that's kind of beside the point, because all precedent is super precedent when it comes from the Supreme Court.
When it comes to, but in your view, it should, based on a different definition of what a super precedent should be, would you, the definition that you cited, 40 years, survived multiple challenges, do you think that Roe should be in that list of super precedents?
Plainly, according to that definition.
So you might not enjoy listening to this, everybody, but it's really important, and I'll tell you why. We know what's going on. President Trump's going to get impeached. He's not going to get impeached on anything of substance, okay? We can go on, we can talk about, oh my God, and I will throughout the next couple weeks. And when he gets impeached, we'll talk about it. And I've spoken about it today. I speak about it every day on the upload. they're going to impeach Trump, and they don't even need to. They don't even need to have an actual reason. What's going to take place is they're going to impeach President Trump. That is, the Senate's not going to convict Trump because he didn't do anything wrong. Okay, Valerie Rogers, thank you. Do you really expect them to be fair? Well, yes and no. I understand that they won't be fair, but I do expect some kind of reciprocity. I expect it. I know that it ain't going to happen. And the reason they're scratching and clawing, the reason they're going to impeach Trump, and the reason they get these intelligence officials to tell on the president, and oh my God, he's trying to go up against, because the notion that Biden is Trump's direct political rival is hilarious. Biden doesn't even want to be president. Biden's losing ground in the polls to people who weren't even in the top three. So who do you think's going to come in, everyone, and save the day? Of course, it's going to be Clinton. I wrote this in the Huffington Post in 2017. In 2017, I wrote, Clinton 2020 is a reality. Get ready for 8 years of Trump. But they did this to themselves. They cheated. They lost. They had every single possible advantage. And the manner in which they want to legislate communication and speech and words and semantics. The First and Second Amendment they'd overturn. They want to do away with the Electoral College. They want to pack the courts. They want to completely rewrite the Constitution because they're upset they lost. They've had a temper tantrum since 2016. So why is this all taking place? Amy Coney Barrett, if there's another vacancy, will be, the next pick. And that's what this impeachment is all about, people. Carl's opinion. President Trump might as well nominate Barrett for the next opening, since anyone he nominates is going to catch a lot of... Exactly. Might as well go with the super conservative. Exactly, but also a very, very qualified... Carl's opinion. A very qualified, eloquent, intelligent, principled woman who they cannot... If they tried to disparage Carl, if they tried to disparage Barrett, they disparage themselves. So... and that's the issue here. Carl's opinion. Everyone subscribe to Carl's opinion. If they have to also, Carl, thank you. Everyone subscribe to Carl's opinion. He's awesome. The issue here is, and thank you as always for your generosity, Carl. Thank you. This is what it's all about, people. It's all about the Supreme Court. It's all about the next nominee. It's all about foreign policy. He's scaling back U.S. foreign policy. President Trump is the president that we need in this day and age. It's a moment. Trump represents a reversal, not of all the good things that Democrats, or good things that Democrats have, you can link to Democrats. I don't know how many of them, but there are some good things. He represents a reversal of all the negative, failed, duplicitous policies of Democrats. The reason they want to pack the courts is because they lost. The reason they want to do away with the Electoral College is because they lost the Electoral College, which is what they knew. The popular vote, when people, I don't get it. Like, well, more people voted. Like, more people voted. They outspent, Trump was outspent 2-1. So let's continue. I mean, she's great. Carl's opinion, thank you. I agree with you on that. But this is, when you listen to her, she's great. C-SPAN. This is C-SPAN, Judicial and Justice Department pending nominations. And they're like, oh, she's going to overturn this and that. No, she won't. She talked about that she'll respect precedent. So.
Thank you.
Senator
Mr.
Lee.
Chairman, I'm out of time, but I do have some other questions that I'd like to submit for the record for both of our nominees.
Senator Lee.
Thank you very much, and thank you for being willing to be considered for these nominations and for bringing your families along. As one of 7 children, I know what each of you probably experiences. You've probably at times been called by your siblings' names, even in a family of 2, and I have a daughter named Eliza, by the way. That probably happens from time to time. I'd like to start by addressing a topic raised by one of my colleagues a few minutes ago and talk a little bit about why it is that it's
So this is Mike Lee, Republican from Utah. Let's see what he says.
often not appropriate for a judicial nominee to speak about his or her opinion about a particular canonical precedent. So I could ask the question, a long line of questions. Do you agree with Marbury v. Madison? Do you agree with McCulloch v. Maryland? Do you agree with Gibbons v. Ogden? And your reaction to that would, I assume, be the same as it was to the previous line of questions raised by my colleague. Is that correct?
Yes, Senator Lee.
Would you agree with that, Justice Larson?
Absolutely.
So what he's trying to say is, why are Democrats so frightened of Amy Coney Barrett? Why are Democrats so frightened of this person? She's gonna agree with precedent anyway. James G. Who will Hillary pick for running mate? James. I have no clue. I honestly, James, I know Clinton is going to save the day and run, and I've known this since 2017. Everything is a theatrical performance and farce, and this election is even more rigged on the Democratic side than even 2016. Clinton was always running and was never not considering running. James, as her vice president, your pick, your guess is as good as mine. You know, I don't know. It could be another woman. It could be Warren. It could be Warren. I don't know. It could be Warren. It could be Elizabeth Warren. It could be Stacey Abrams. It could be Pete Buttigieg. It could be any. I'm not sure. A man, if it's a man, it could be Pete Buttigieg. Could be, because she ain't gonna go with what's his name again, Tim Kaine. Tim Kaine actually has a lot of some good qualities about him. He wanted to do away with the AUMF, the authorization for use of military force, which I agree with. I don't agree that's even. I don't even think it's constitutional, but that did not do Clinton any favors. In addition to being unelectable, Madam Secretary is unelectable. Like I said, they don't care if they lose or win. But let's continue with this. Thank you, James. Thank you.
And the fact is that this is not about being able to talk about Supreme Court opinions. The point here is that there are certain cases that form part of the canon of our legal system. And those cases are not up for debate. Those cases are not appropriately debated by members of our judiciary. When a case comes up, you're expected to rule on the basis of the law and the facts before you in that particular case. And to the extent the case we're talking about forms part of the canon of the law that you're required to apply, it will have been inappropriate and unfair to the litigants appearing before you for you to have expressed a personal opinion on that particular line of cases. So with respect to my colleague, I do not believe, and I strongly disagree with the characterization that it is in any way, shape, or form inappropriate for you to not answer that question. Ms. Barrett, I want to start with you on a couple of questions. Some of my colleagues have asked you a few questions about stare decisis based on one of your academic pieces that we've discussed earlier in this hearing.
So they're going to devote their lives to, and even look, you see Mike Lee of Utah. They're being so deferential. Oh, you wrote this 20 years ago. Oh my God. Oh my God. It's like she stated categorically she does not feel that a person's, faith-based viewpoints have anything to do with yes, Nicole. Just watch the other channel on Fartgate. Yeah. Thanks for the good laugh. Thank you, Nicole. You know, Nicole, everyone, I know who, on a different note, it was Chris Matthews. He's the one who dealt it, and he smelt it. It wasn't Swalwell, believe me. It wasn't Swalwell. Okay? You heard it here first. Okay, you heard it here first, everyone. I know. I'll be the only person in all of YouTube and all of media, really, to have called this election 3 years before it even... It'll probably be one of the biggest political calls of all time. You know, one of them. If not the biggest, I don't want to brag. Not about me. But, ladies and gentlemen, it wasn't Eric Swalwell. It was Chris Matthews, and he won't own up to it. But check out H.A. Goodman's other channel, because I explain, and I can explain it now. I won't get into too much detail because it's a live stream, and I want to just, abide by protocol on the live streams, whatever. Swalwell was standing up in a very loud Capitol building. He was on Capitol Hill, and he was like near a stairwell or whatever. And the reverberation, if you will, enjoy the visual, but definitely don't enjoy the smell. You cannot. I've been on CNN before. You can see it on my website, but I've been on CNN. I've been on MSNBC. I've been on CNN 3 times, MSNBC twice. I've been on RT like 10 times. And if you put a mic on a lapel or on a jacket, you're sitting down in a studio where there's no background noise, you're going to hear that type of thing. It'll be very audible. Plus, if you're sitting down, the sound is going to be more audible if you're sitting down in a studio where there's no background noise. It's not going to be audible if you're on Capitol Hill and you're talking, you're standing up. And unfortunately, it wasn't Swalwell. Believe me. It was, ladies and gentlemen, Chris Matthews. But let's continue.
Everyone tends to talk about stare decisis from an institutional perspective, as you correctly point out in your piece. But you take the somewhat different approach of considering stare decisis from the perspective of individual rights. In other words, when a court is following the doctrine of stare decisis, the court is effectively foreclosing the right of an individual litigant to raise effectively or with any hope of being effective in raising.
But Eric, you gotta. So I'm looking at Eric H526. Eric said, Eric has some great lines, ladies and gentlemen. So wait, what did Eric wrote? I see your point, HA, but I think it's. Oh man, why can't I see this now? Eric, you gotta also understand, Chris Matthews would easily divert the attention to Swalwell. Do you think he's going to be honorable and say, yeah, it was me? No way. Come, let me tell you. The guy who made out like a bandit, like a methane billionaire, was Chris Matthews. He was sitting and he didn't realize, whatever. No, I don't know what he ate for lunch. I don't want to know. I don't want to get into it. This is about the Supreme Court. But Chris Matthews did It couldn't happen to a better guy. Couldn't happen to a better person. Swalwell, oh my God. You're talking about a discarded Ken doll, a discontinued Ken doll that was just like too pretentious to keep making. But that sound could only happen in a studio. So, now I will say this. Eric H. Fudges. Now, I will say this. Yes. He kind of moved his shoulders up. I get it. I'm unsubbing. It was Eric Swalwell. He moved his shoulders up, which gave but he was moving his shoulders, if you notice. He was moving his shoulders a lot during Trump did this, Trump did that, so he was moving his shoulders. Perfectly timed. I get it. It was perfectly timed to where you're like, oh, It was so funny. No, for sure. It was so funny. But you see, that's the way Democrats, that's the way they do. They will accuse one another of that type of behavior without being honorable, saying, and then they say it was the coffee mug. On what planet would a coffee mug make that sound? On what planet? I want to know what planet. They're like, it's just the coffee mug, everybody. Soon you're going to be saying that Bernie Sanders was cheated. It wasn't a coffee mug, and I've never seen a coffee mug make that sound. What kind of desk and coffee and cup would make that sound? They're like, it's a coffee mug, get over it. Like, no.
A particular argument before the
Now let's get back to the Supreme Court.
Is that an accurate characterization?
Of the start.
Only in America could you talk about that subject in the Supreme Court without even batting an eye.
Decisis and due process article, yes, Senator Lee.
And so in that respect, it's an imposition on individual liberty, on the ability of an individual party to
Timber maniac.
Or to a criminal matter for certain arguments.
Yes.
Timber maniac.
Now, I'd also like to address the following point. During Justice Kagan's confirmation hearing, she was asked about a bench memo that she wrote while serving as a law clerk on the Supreme Court of the United States, to Justice Thurgood Marshall. In that memo, she had written, quote, quite honestly, I think that although the lower court's decision is well-intentioned, parts of it are ludicrous. She went on to recommend that Justice Marshall vote against certiorari because other justices, quote, might create some very bad law on abortion and or prisoners' rights, close quote. She was asked about her feelings about that, and here's how she responded, quote, when I was clerking for Justice Marshall, I was 27 years old, and Justice Marshall was an 80-year-old icon, a lion of the law. He had firm views, he had strong views. He knew that he thought about a great many legal questions. He had been a judge for some fair amount of time, close quote. The committee accepted that answer, and
so when Elena Kagan said, I did write something with Thurgood Marshall, who is, a legendary Supreme Court justice, Democrats are no problem. Like, okay, you changed your mind? Okay, no problem. And you wrote something because somebody of greater stature was the co-author? Okay. But they won't afford Judge Barrett that understanding. It's really interesting.
Went on recognizing this fact that Justice Kagan's views in her 20s would not necessarily be the same views that she might take today. Do you think that's a fair way of approaching that?
I do, Senator Lee.
Justice Larson, after Justice Scalia's death,
All right, so that's something, it says everything you need to know. Here, let's this is a great one. So we got
on the lives of countless Americans.
So Richard Blumenthal, he's fantastic in every way. So let's listen to Blumenthal. This guy's hilarious.
Well, Senator, I don't think I ought to express personal opinions for the reason why nominees have drawn that, for the same reason that nominees have given in the past. But I do think
you for your personal opinion about right or wrong. I'm asking you the same question, in effect, that you were apparently asked in 2013, and you said it would have no effect. Would you continue to say that now?
Well, Senator, in the context, I think we're talking about it in a different context
You're
than
here
it was.
in this context. I'm asking the question in this context.
In this context, if you're asking whether it would be disruptive to overrule Roe, I guess I would say, again, with the Supreme Court citing Casey, that if Roe were overturned, the court made very clear that there would be a disruptive effect to women's lives. The court also referred to the disruptive effect for the court's legitimacy.
So
and
you would agree
court.
with the court in Casey that its effect would be disruptive?
The court said in Casey that the effect
you
would be
agree with the
disruptive. All Supreme Court precedent I'm going to agree with. If I'm on the Court of Appeals, I embrace it, and the court described it that way, and I embrace the court's precedent.
There you go. Case closed. Case closed. What more do you want? The great thing about Amy Coney Barrett is that she's already they don't have anything else. They do not have anything else to complain about. Literally, the only thing they have to complain about was that she wrote something 20 years ago, and within the context, that is not her viewpoint today. Not at all her viewpoint. So, that's the issue. That's the issue. Ladies and gentlemen, I first want to thank you so very much. I know that this might not have been as amusing as my analysis and my evaluation of Chris Matthews and his diabolical deed. Believe me, I wish it was Swalwell. The fact that people are saying it's I don't know which is funnier, that or the fact that he wanted to run for president. But it wasn't Swalwell, it was Chris Matthews, and I explain exactly how the dynamics behind it, the physics. I get into it, people. Check out H.A. Goodman's other channel right now if you want to find that out. Share that segment. Because this is one of the most pressing concerns Americans have. And I deliver the goods on that. Anyway, thank you so very much. Carl's opinion, thank you. Everyone, thank you so very much. God bless. God bless everyone here. Thank you, everyone. And what can I tell you other than you're all wonderful, and we will have an amazing year together. And beyond Trump's getting reelected, it's a matter of what Democrats do to help install Madam Secretary, because Clinton is going to be the nominee. Clinton's going to be the nominee, everyone. Tell your friends that Clinton's going to be the nominee. Tamra, I have a Patreon, and the Patreon is below in every one of my pinned comments in both channels. Tamra, and my Patreon will be below below this segment also. But every segment I do, the Patreon is a little bit below the pinned comment. Just scroll down, you can see it. Thank you so very much, Tamra. Anyone, thank you very much also, Tamra, for your support. Thank you. Everyone, God bless. I'll see you tomorrow. Get a good night's rest. And it was Chris Matthews. It was Chris Matthews.